Good evening. I'm Chris Matthews in Washington. In a minute, are Republicans ready to kiss off the Latino vote? Just tell them to take their vote and shove it? Are they? And does it now look like Edward Snowden is truly a man without a country, even one that'll take him? But let me start tonight with the biggest trial in the country. This case will come down to whether George Zimmerman believed he faced great bodily harm or worse at the hands of Trayvon Martin. What did happen in court today to show that was or was not the case? NBC News correspondent Craig Melvin joins us now from Sanford, Florida. Craig, thanks for joining us. This trial in just the last couple of days has had a lot of twists and turns, and I just wonder about the prosecution. Their witnesses are not exactly going in the direction, I think, that they hoped they would.
Yeah, you know what, Chris, that's the point that's been raised a lot today and a lot over the past few days. Specifically, Mark Osterman was one of the witnesses that the state called today. Mark Osterman, he gets on the stand, and within the first 90 seconds, we learn that he is George Zimmerman's best friend. He said at one point that he's the best friend I've ever had. They've known each other for about 5 years. He wrote a book defending George Zimmerman. He and his wife did an interview with Dr. Phil at one point, and in the interview, Dr. Phil, in the interview with Dr. Phil, the wife said that George Zimmerman deserved Trayvon Martin deserved to get shot. The day began, Chris, with Judge Nelson ruling on Chief Investigator Chris Serino's testimony from yesterday. Chris Serino at one point yesterday, of course, toward the end of the testimony, Serino said that he essentially believed George Zimmerman. That was the testimony at the end of yesterday. There was, of course, an objection by the state. Judge Nelson this morning told the jury that was something that they should essentially disregard, that he should not have been commenting.
What do you think of that as a reporter? How do you disregard something like that? I mean, I remember a great movie called Anatomy of a Murder where the defense attorney in this case said, don't think of a blue cow, knowing that there's nothing else you can think of for the next 5 minutes except a blue cow. How do you strike it from your memory if you're a juror sitting there?
Once the toothpaste is out of the tube, right? That's a very good question, and we should note here that the day ended sort of akin to how it ended yesterday, with folks waiting on another decision by Judge Nelson. Tomorrow at 8:30, the attorneys are going to continue arguing over some evidence that the state would like admitted, Chris, specifically some coursework on self-defense law, some coursework on stand your ground law that George Zimmerman may have taken, an application to become a police officer with the Prince William County Police Department, not far from where you are, Prince William County, Virginia. Yeah. And also this application that George Zimmerman submitted to participate in a ride-along with Sanford Police. Basically, the state is asserting, part of their assertion all along is that George Zimmerman was a wannabe cop, that he was a wannabe cop. And they also played that interview today, that Fox interview where he was asked pointedly, did you know anything about stand your ground when you did this? And George Zimmerman said no. So now the state is trying to introduce evidence that would speak to the contrary. So Judge Nelson gave the attorneys some time to introduce some case law. We expect that she may rule on that tomorrow, but we know at this point that the attorneys are going to continue those arguments at 8:30 before the jury is brought back in after.
Well, that's great reporting. Thanks, Craig Melvin. We'll be back to you again and again. Join me now is veteran prosecutor and former San Francisco Assistant DA Paul Henderson. There he is. And defense attorney Karen DeSoto, both of you. Well, let's take a look at some of the trial testimony before we get into this general conversation. Let's take a look at the conversation here. Let's go to, they called Zimmerman's friend, as we said, Mark Osterman, to the stand. Osterman wrote a book, as it's been said here, defending Zimmerman, called Defending Our Friend, the Most Hated Man in America. Well, Osterman described what Zimmerman told him happened at the crime scene. Let's listen to the testimony.
What does Mr. Zimmerman, defendant, say happened then?
He said that because his jacket rode up a bit, that perhaps with the inside of his leg, he felt or looked down and saw that he had a holster and a firearm.
Okay. Before the defendant said that, did he say that he desperately got both of my hands around the guy's one wrist and took his hand off my mouth long enough for me to shout again for help?
Right. That was the main thing he did with his hands, was to try to clear his mouth. Because with his mouth free, he could scream and he could breathe.
Well, later in the trial today, lead defense Mark O'Mara asked Osterman, that same witness, about George Zimmerman's recollection of events.
Did that, however, as he related it to you, seem to be significant as it was occurring to him, that he couldn't breathe for whatever length of time?
Yeah, it was critical.
And that somebody had a hand, Trayvon Martin, on the nose that had already suffered the previous injury.
Correct.
And as he was relating that to you, was that sort of a real focus of his?
That was the focus. That when he was losing oxygen, he felt he was not able to breathe, and that's why he was desperate to either clear an airway.
And in your experience as law enforcement, would you agree that that's sort of a natural reaction to traumatic events?
I would think so, every time I've seen it.
And do people involved in traumatic events like that sometimes focus on particular parts of it?
Almost exclusively to the omission of others.
Well, let me go to Karen DeSoto. It seems to me, talking to Lisa Bloom last week, a pretty good defense attorney, that what this trial is going to come down to, after all the other discussions, relevant or not, as they go on, deciding by the jury whether they're relevant or not, we're going to come down to a question of the defense here, which is it's self-defense. That's the defense. Right. And whether the defendant here in this case, George Zimmerman, believed at the time he made that decision to draw and shoot his gun that he was in danger of gravest bodily harm. Right. And now we're getting to testimony which doesn't seem to be challenged yet, that there was a fight, there was a physical brawl, he was on a sidewalk, that apparently got agreed to that at some point, his head was hitting the sidewalk, and then the question is, how many times does your head have to hit the sidewalk before you wonder if you're going to get grievous bodily harm or not? Right. I mean, are we there, or is that not stipulated at this point? Are we that close to what's the margin call here? What's a judgment call, or what?
Well, you know, there's one point. The self-defense is by a preponderance of the evidence, so it's not a reasonable doubt standard. So it's 50. It's more probable than not. So if you're at 51% and the jury believes by 51% George Zimmerman's version of the story, then obviously self-defense is going to win out here. But yeah, I mean, how many licks does it take to get to the center of a Tootsie Pop? How many bangs on the head does it take until you're brain damaged? So that's a question of fact that the jury has to determine. But in determining that, you also have to remember that the standard is a lot lower for the self-defense.
Yeah, well, let me go to Paul Henderson. I want to get the facts straight. I'm not watching the trial every minute. I got another job to do here. It's called politics. And this is, of course, in general sense, I guess, political, but because it's about the ethnic issue. Let's face it, race is part of the way people look at this trial. And I'm wondering whether people are learning anything in this trial who watch it incessantly. Do you have a sense that it's a learning experience, or is it just two sides looking at each other across the old racial divide and saying, I see it my way, you see it your way, we ain't changing?
You know, it's funny you mention that, because I get calls almost every day from people that are watching this trial, that are calling me and asking me questions. I have a little brother that's in law school that calls every time something happens and wants to know, like, why is this happening? But I think the real effect of what's going on in this case is still being seen outside of that courtroom, where we just saw just last week the U.S. Commission on Civil Rights is opening up an investigation to evaluate the stand your ground laws. And so I think
but they're not invoking that here. That's not the defense. It's common law self-defense, I believe, that's at issue here.
You're absolutely correct, but I think this trial and the discussions that are prompted because of this trial are causing people to look at the stand your ground and evaluate what is a result of stand your ground, and is this trial one of the results from having that law on the books? The approach that the government is looking at is whether or not there's a racial bias. You know, stand your ground.
I mean, these are all relevant questions in our society, but I want you first, and then let's go over to Karen. It seems to me, if the facts are here, and I agree they're not stipulated, but if a guy's on the ground and somebody's pounding his head into the cement, he doesn't really have a choice about whether to stand his ground or not at that point. Certainly before the scuffle or the altercation or the fist fight began, he had the choice of getting back in that car as fast as he could, maybe, and getting the hell out of there if he saw this guy as a threat to him. Right. Let me go back to that question, though. Is it going to be stand your ground? In reality, when it comes to that jury decision, is that going to be the issue in that courtroom?
No, the issue in that courtroom is going to be whether or not he used too much force in retaliating and using self-defense, because we're looking and we're hearing this evidence about what his injuries were, that they were de minimis, that they weren't that significant, and so he's going to try and he's trying to paint a picture that his life was in danger, and that's exactly why he pulled the gun out.
I can tell you, watching this and hearing people say, Karen, he has a couple of lacerations on the back of his head. Now, the word laceration just jumps upset. And then somebody says, well, they weren't that serious, the lacerations. And then you get back to what you just said about the 50%, 51% preponderance.
Right.
When it's your head being smashed, it's like being on an airplane.
Exactly.
You worry about that plane in turbulence. But when you look up at the sky and see a plane, you never worry about the turbulence.
Right.
You're not on that damn plane. You're
with
watching
my
it.
thin
But if it's your head, you have a different view of things. Yeah. So the question, if it's a juror's decision, how do they? It seems to me there's so many cultural and value. I mean, 450 years of racial prejudice in this country, and slavery, and all the horrible things, and bad police behavior, and all that bunched together, and you kind of try to get a verdict out of that, or you're trying to get a verdict out of the limited circumstances of two guys duking it out in the dark,
Chris,
and trying to figure out what that meant.
The racial angle, as a defense attorney, because the emotions are running so high here, what I would do is argue the facts, and at the end of the day, the prosecutor decided to charge second-degree murder. Okay, the unlawful killing of a human being.
Was that too high?
Perpetrated by any act imminently dangerous and evidencing a depraved mind. That is an extremely high standard. So you don't even have to get to the emotional of it.
Right,
if you're a defense attorney, you can just argue the facts. You can argue the standard. I mean, they chose not to go with manslaughter. They went with the second degree. I
agree with you. I got to give Paul one chance here. Was manslaughter a smarter move here to get a conviction, or can jury still go for manslaughter if they decide second murder is too high? Can they make that choice?
I don't think so. And to me, as I look at this trial and through the lens of a prosecutor, and I'm hearing the evidence about how he approached Trayvon and literally hunted him down with his gun, I think the facts and evidence are really going to support those charges. Because here's the linchpin for me. And I haven't seen this question asked, but I really want to know, with that semi-automatic gun, at what point did you take the safety off and prepare to shoot someone? Because if you were doing all of that, or did this all happen in the moment while you were being smothered and your head was being bashed with the de minimis injuries? Because all of this reflects to me, in the grand total of the evidence that I'm hearing, that this may not have been an accident. This may not have just been a self-defense situation. This may have been a little bit more than that, and that Zimmerman acted inappropriately and could be found guilty in this case.
Right, you still have to prove it. Anyway, thank you. We got to go, Paul. We'll be back. Please come back. I can't just have a battle of great attorneys here. Okay, thank you, Paul Henderson. Thank you, Karen DeSoto. Coming up, why many in the GOP decided they don't need Latinos at all politically. An emerging